Hello, listeners, and welcome to another episode of the Jacob Shapiro podcast. As usual, I'm your host. I'm Jacob Shapiro. I'm a partner and the director of geopolitical analysis at Cognitive Investments. Joining me for the second time is Matthew McClintock. He's founder and executive managing director at the Bespoke Group. Matt has already been on once, and we're hoping to make this as close to a monthly appearance as we possibly can. Bespoke and Cognitive are also strategic partners and doing more work together all the time, so it's really nice to get together from that sense. We talk about trusts, and I don't want to scare you off. We make it geopolitical at first, we get a little wonky, and then we pull back and talk about some philosophical issues, some issues about privacy, and why this is really a conversation that everyone should be having. There are certain levels of this conversation that might be more applicable if you have more money. But I thought the most compelling thing, and the one thing I would take away from this podcast, is some of the structures that Matt is talking about. They're for everyone. They're not for people who have bajillions of dollars. So if you do have bajillions of dollars and you want to talk about that, you know where to find me. But I hope that this was at least edifying in some way. And I'm trying to talk about some of these issues in a way that is engaging, in a way that is not morbid, but allows you to exert more control over things that you do have control over, even though it may not feel like you always do. So email me at jacob@cognitive.investments if you'd like to chat about anything that's on your mind. Otherwise, take care of the people you love, protect your data and information. Cheers, and see you out there. All right, Matt, thank you for rejoining the podcast. I usually record in the morning. It's a rare pleasure to record in the afternoon with my Richard Sparkling Rainwater. How's it going?
It's going well. I mean, we should turn this into something a little bit harder than sparkling rainwater. I think
we should. I can hit the button on my standing desk, and you can see the bourbon collection that will appear to the top left of my head. But that only happens when I'm trying to look unprofessional.
We'll do that another time, maybe.
We should actually start a game. I was thinking of starting a game where I had to donate money to a charity anytime anyone mentioned Peter Zeihan on the podcast. But maybe it should be I should take a shot anytime anybody mentions Peter Zeihan on the podcast. I don't know. Anyway,
really interesting.
It would get really interesting really fast, or at least amusing for some folks.
Your viewership and listenership would go in one of maybe a couple of different directions there. So I just don't know.
Yeah. It's kind of like that drunk Shakespeare phenomenon. Anyway, we're really digressing here. Last time we talked, we sort of did a broad talk about personal sovereignty and planning and why we're going to make planning important and relevant to the listeners. And so the topic I thought that we would tackle today is trusts, because when we were talking back and forth about potential topics that we would talk about, this was one of the things you talked about, what everyone needing one, key decision points and how to structure them, things like that. But in my never-ending quest to make everything geopolitical, it was actually incredibly easy to make trusts geopolitical. I'm going to assume that you know the answers to these questions, so I'm asking mostly as a surrogate for the audience. But do you know where trusts come from, where the first trusts come from, and where the concept of trusts come from?
Yeah, you've been down this rabbit hole a lot more recently than I have, but it had to do with when knights would go off to battle, they would entrust their estates to a trustee who would take care of the land, oversee the crop yields, manage the servants, and just make sure that everything was in good stead. If and when the good knight came back from his quests, that's my recollection, at least.
You've got it dead to rights, although apparently there is, like, the very earliest genesis of the concept is in Roman law, again, because soldiers are going away to battle, and soldiers would put their property, which only other Roman citizens could own, like they would be responsible for tending to that property, and they would give it back if the Roman soldier came back. But it was sort of informal. It had more to do with, it was like an ethical position rather than a legal position. It maybe changes a little bit towards the end of the Roman Empire, but it doesn't really go anywhere. But that is the genesis of the idea. And you're exactly right. It's when the English knight, it's not just when he goes off to battle, it's when he goes to fight in the Crusades. So it's specifically this geopolitical conflict happening in the heart of the Middle East. So, like, nothing actually ever changes in the world. These knights would go off to the Middle East to go and fight, the Holy War. And when they came back, the trustee didn't have to give back the land at all. And so what happens is they then have to go and petition the Lord Chancellor, who would hear all of these different cases and eventually rule in favor of the crusading knight that went away, or at least that's the way we think it would probably go. And over time, that becomes a precedent and eventually becomes what trusts are known as today. There's also, though, a really interesting segue, courtesy of Henry VIII. because in the 1500s, what happens is what began as a way for these crusading knights to keep their property under protection from somebody who's using it becomes a way to avoid taxes from the English sovereign. And Henry VIII is spending a lot of money and trying to, fight a lot of foreign wars and things like that. And he doesn't like that. So he tries to pass something called the Statute of Uses in 1535. And some of that gets changed with property, and this all gets duked out later. One of Rob's favorite topics on the podcast, as listeners will know, is the English Civil War. Here's one moment, Rob, where I could actually use your expertise on the English Civil War, and you're not here, alas. But it's funny, as Henry VIII goes after these property issues, he actually creates a lot of categories for other things outside of properties that eventually become trusts. There was also I went down a weird rabbit hole where there were certain orders of monks, like specifically the Franciscans, who swore an oath of poverty, which meant they could not own land directly. So they had to create structures where something would own their abbeys and their priories and things like that, and allow them to fulfill their oath of poverty, but at the same time enjoy the benefits of land rents and free accommodation or anything else that they were doing. So interesting that even at the heart of something as mundane as you might think is a trust is actually like the entire reason for this coming up in English law was because of the Crusades, which it doesn't get much more geopolitical than that. I thought that was incredible.
For sure. And it's interesting how there are echoes of that in even modern trust constructs and modern wealth constructs, how you structure around this. Under the laws of every state in the United States I'm familiar with, at least, you could even have an oral trust. It's not even reduced to a writing anywhere. You can simply say, I, Matt, entrust you, Jacob, to manage my affairs for me while I am gone for some period of time. Of course, the question then becomes, how can you substantiate that I created this trust for you? But you can even create these oral contracts that have the weight of law. And I'm sure it goes all the way back to those conquest days.
Yeah. And then my last sort of trivia points for us is that there actually is some disagreement about where the actual idea comes from. Like some say, no, it's not the Romans. It's actually some Germanic tribes did this sort of thing, and the Romans just stole it for themselves. But I also read an interesting article from the 1920s in a law journal in the United States about the concept of waqfs in Islamic law, which is actually kind of similar when you get down to it. If you go to what is today the Dome of the Rock or the Temple Mount, if you're of that persuasion, like that's under a waqf technically. And that's, again, a way of Islamic law doesn't look kindly on things like charging interest or land ownership and things like that. So you create these structures where things can be owned by other entities for whatever purposes. And then kind of back it in there. So it's not even a concept that is exclusive only to English law, even though English law is where it gets sort of ensconced and is probably the basis of most of the law that we're going to talk about today, because it seems like for most of the 1800s, American lawyers were just copying and pasting what they were doing in England and sort of slapsticking on here before American trust law really takes off. But I thought it was interesting too that you don't just have to be in the Western white guy canon to get these types of instruments. It seems like different societies and different religions have needed these kinds of instruments throughout history.
That's right. And I know you've got an international audience on your podcast, and trusts are usually pretty unusual for people who don't have an English common law background. But there are analogs to it in other jurisdictions. Foundations are often used in civil law countries. We don't usually use those here in the United States. I mean, a lot of people are familiar with the concept of a charitable foundation, but that's something altogether different. A foundation in a lot of the rest of the world is simply a corporate form of ownership that operates for all the world like a trust, but just kind of in a wrapper of a company instead of in a wrapper of a contract. So you can have a foundation that has a founder. I might want to set aside some of my assets in this foundation, and that foundation is led by a board of directors that I can appoint, I can remove, but nobody owns that foundation. I can simply create this foundation, sometimes with infinite life, and create a charter for that foundation, and that creates an opportunity for managing my family's wealth if I'm in a jurisdiction that doesn't recognize the common law of trusts.
Mm-hmm. And I don't want to wax philosophical too long here because I want to get down into the actual brass tacks. But one of the reasons that I wanted to bring up the history here was because, and as you exactly point out, it's English law and then American law that is defining a lot of these things that we're talking about right now. And if I'm right about the themes that I talk about on this podcast all the time, which is we are moving towards a multipolar world, whereas it is not the United States that is calling all the shots, where there is not one international law system that is respected by everyone. There's two things there. You're going to have the equivalent of English crusading knights who are going to need trustees to help them with their capital as they move from place to place. And probably the rules of the game are going to change depending on where you are and on what sovereigns want from you. Again, like the example of Henry VIII deciding, I need to fund my foreign wars. I'm going after this thing that's been operating for 300 years. Nobody bothered them because it was just a way to protect the English crusading knights and then avoid some taxes from the sovereign. Like all of those types of issues. It is not a stretch to think about how what's happening in the world today can lead to this becoming a much more operative conversation than it has been, I think, recently.
Yeah, that's right. And you're kind of alluding to something else too, which is in a multipolar world, and especially in the higher strata of wealth, like the clients that you and I get to work with, um, they very often have a global perspective in their investments as well as their actual holdings, and you really have to tailor the strategy, the legal structure to suit the jurisdiction where you're operating. So you could be a U.S. based client who has probably a multitude of different types of trusts that are designed to do certain things, whether in the United States or in some other jurisdiction that derives from English common law. But if you've got interests in the Iberian Peninsula or other places in Europe or maybe Africa or whatever, a different type of legal structure is going to be appropriate because now you're dealing with local bureaucrats, local regulators, local investors who need to have something that they're familiar with so they can interact with it appropriately. So global families need to have global legal strategies, just as they've got global investment strategies.
Yeah, exactly right. So that was easy. Like I didn't have to stretch at all to make this geopolitical and make the case for why geopolitics is at the core of this. Let's start very simply then. What is a trust?
A trust is really at its bare essence, it is a legally enforceable agreement among parties where the settlor, the individual who creates the terms by which the trust is going to be administered, entrusts certain property to someone who's going to serve in a fiduciary capacity to manage that for them. That person is called the trustee. And the settlor establishes this agreement with the trustee to provide certain benefits to individuals or causes, those being the beneficiaries. Really, at its core, that's all we're talking about. And again, that goes all the way back to the beginning of this geopolitical conversation. But part of why it has so much value now, I think, in the kind of in the main, especially when we're dealing with families of any kind of affluence at all, is it allows for the structured, predictable, private management of family affairs without necessary intervention from an arbiter, like a judge sitting in a probate court somewhere. I know you've mentioned on the podcast before you're dealing with some of this yourself. The type of trust that most people will be familiar with is what's called a revocable living trust. It's simply a trust you create during your lifetime for the purpose primarily of simplifying and privatizing the process of making decisions for you and for your other loved ones if you're not around, if you've become incapacitated, or if you've died, so long as the creator of the trust has selected an appropriate trustee, they've made their instructions clear, and they've gone the extra step of transferring ownership of their assets to the name of the trustee in this trust, then we have now shortcutted the probate process here in the United States, or the guardianship or conservatorship process in the event of a disability.
Yeah, you're exactly right. So by the time this podcast will have appeared, I will have already presented myself at the probate court of Newton County in the state of Georgia. But I'm going there in 2 days to do that. Nothing can be worse than jury duty in New Orleans, though. So I'm expecting a little bit better than my time doing jury duty in New Orleans, which I'll have to raise the standing desk and get the bourbon out if we're going to talk about that. What is the difference between a revocable trust and an irrevocable trust?
Yeah, it's there's actually a more granular question than that, I think, or more granular point of analysis. What makes a trust revocable is the settlors retaining the ability to change the trust. So again, that's why that's the thing that most people are familiar with, the strategy that most people are familiar with, because as circumstances change, my objectives might change. I could always modify that trust. But if I become incapacitated or when I die, that trust has become irrevocable because the party who had the power to revoke it no longer has the power. So any revocable trust becomes irrevocable at least when the settlor has died. But a lot of people, there's a lot of reason that you might create an irrevocable trust during your own lifetime. And that can run the gamut of shifting value out of your estate from an estate tax perspective. So if you're a highly affluent person and you're at or above the federal estate tax exemption amount, you expect your wealth to continue to grow, and you want to take advantage of high federal estate tax exemptions right now, get the future growth outside of your estate. There are certain types of irrevocable trusts that would allow you to make what's called a completed gift. So once you have put the assets inside there, you no longer have the ability to claw it back. The future growth on those assets can escape federal estate tax. And if you're in a state that has a state estate tax, it escapes that as well. And when structured properly, those trusts can continue for many, many generations and avoid the estate tax generation after generation after generation, allowing family wealth to compound without the erosion of state or federal estate tax. But that's just one form of irrevocable trust, or one reason people might do irrevocable trusts. Other times people will create an irrevocable trust because they want to preserve some type of asset protection over the assets inside those trusts. They want to put a portion of their wealth beyond the reach of some future creditor that not on the horizon now, but may arise somewhere down the road. So there are certain types of irrevocable trusts that do that. But really, when you're talking about an irrevocable trust, you're talking about some decision point that gets you to where you either need to or simply choose to fundamentally change your relationship with the assets inside that trust. Because by giving up the right to revoke the trust itself, you're making a decision that's pretty darn permanent. And we can maybe talk around how you can make modifications around the margins through third parties, but you really kind of need to say, look, these are assets that I really want to kind of set aside either for a rainy day that I hope never comes, or for transgenerational wealth for multiple generations of my family.
Mm-hmm. Are there any other categories of trusts we should talk about? So we've talked a little bit about revocable and irrevocable. Are there any other categories we should talk about before we get a little deeper into those two main categories?
Yeah, I mean, I hope this doesn't get too wonky, but I mean, I've listened to your podcast enough to know that you like to get wonky. So
I do, and anytime it gets too wonky, I'll either bust out the bourbon or we'll talk about the Crusades again. Like don't worry, you're playing with house money.
Perfect. Yeah, so in the world of trusts, you have a few broad categories. You have trusts that are revocable versus trusts that are irrevocable at inception. When you're dealing with irrevocable trusts, you've got a couple of different subcategories. With an irrevocable trust, you might have one that is a completed gift for federal gift and estate transfer tax purposes. Those completed gifts will use up part of your estate tax exemption amount, which is currently $13.61 million per U.S. taxpayer. But then if you don't have any estate tax exemption left, another type of irrevocable trust is called an incomplete gift trust. And so you might have an incomplete gift where you've retained the ability not to revoke the trust, but to appoint the property in some different direction in the future. So if you have no estate tax exemption left, you might create an incomplete gift irrevocable trust. There are trusts that have what are called split interests, where you give away part of the trust, but you keep part of the trust. So these are things that some of your listeners might be familiar with if they've kind of gone out into some of the thin branches. Things like GRATs, grantor retained annuity trusts, are probably the most commonly understood form of a split interest trust. It is a irrevocable trust that says I'm making a gift in trust. It's a completed gift in trust. So the value that goes into this trust will be out of my estate from an estate tax perspective, but I am retaining the right to annuity payments from that trust for a period of time. And so I might create what's called a 5-year GRAT. And so that means I put assets inside this trust for 5 years. I get an annuity from that trust. And at the end of that 5-year period, whatever is left inside that trust goes to other beneficiaries, usually my children or siblings or other people I want to provide benefits for. So that's a split interest trust. There can also be charitable versions of that as well, which people can do from a tax planning perspective. And then I think the final subcategory really gets into some of the income tax side of the conversation, which is called a grantor trust versus a non-grantor trust. So a grantor trust, again, this only applies in the irrevocable trust context, because the revocable trust is by its own definition a grantor trust. What that means is the creator of the trust, I used the term settlor earlier, the tax term is grantor, who's the owner from an income tax perspective. If it's a grantor trust, I, as the settlor, am treated as the owner of that trust for income tax purposes. It might be a completed gift, so the value of the assets are out of my estate, but I might be the grantor for income tax purposes, which means that all the income, any deductions that are at the trust will flow through directly to my individual 1040. And the trust is also subject to taxation, if you will, at the ordinary income tax rates for individuals, because I, an individual, am treated as the taxpayer for income tax purposes. Those can be really effective because every year that I make the income tax payment for the income that's earned inside that trust, that's my own direct personal liability. And so the value continues to compound inside the trust without being eroded by the income tax payments. So when I pay the trust's income tax each year, it's as though I made a free gift to the trust, because the trust is not losing value by paying its own income tax load. There's some other really interesting things I can do with grantor trusts. I can engage in sale transactions back and forth between me and that grantor trust to shove more value outside of my estate. But we're starting to get into some thin branches there. The opposite of a grantor trust is a non-grantor trust, where the trust itself is the taxpayer. And on the downside, a non-grantor trust, it has to pay federal income tax at compressed rates. Trusts get to the highest marginal tax bracket at around $13,000 or $14,000 worth of income. So it does carry a higher federal income tax load. But if you are in a jurisdiction like Maryland or Massachusetts or Oregon or California or some other state that has a high state level income tax, you can sometimes create an irrevocable non-grantor trust that's a separate federal taxpayer, and you set that up in a jurisdiction that has no income tax, like South Dakota or Wyoming or Nevada or someplace like that, and then you can sometimes escape your state level income tax on assets that are inside that trust. So, an example might be founders equity or founders tokens in a crypto project or something like that. You're going to have a large income tax recognition event someday. Maybe you want to kind of hedge. If you're in Oregon with a 9.9% income tax, maybe you want to get to save an extra 5% on your taxes by doing one of these trust structures that's a non-grantor trust. So to kind of quickly recap, you've got revocable and irrevocable. Within irrevocable, you might have completed gift or incomplete. You might have a split interest gift, and it might be either a grantor trust or a non-grantor trust.
I feel like one of the places where, when I'm talking to people about trust in particular, that their eyes start to glaze over because we've come a long way from talking about, I'm a knight who's going to the Crusades. Please take my property and manage it for me and manage the peasants. And when I come back, please give it back to me, to the things that we're talking about right now. And like part of that is also like, that if you have a trust, can you name yourself the trustee of your own trust? Like, what is your own personal relationship with lots of the different entities that we're talking about in here? So I guess I'm going to give you a sort of free-form question to talk about how this has evolved over time, where it went from holding something in protection from somebody who literally couldn't access to it to now sleight of hand is the wrong thing, because that, I think, adds a pejorative light to it. But protecting from a government taking parts of it away, like we're worried more about Henry VIII than we are about somebody keeping this safe. Does that make sense?
Yeah, it does make sense. I think there's a lot in that, and I want to make sure that I think it through a little bit. In the case of, I want to kind of tie this back a little bit to the knights and the soldiers going off to battle. I mean, you could certainly see a world where the knight has pastures that will yield a crop, and he may say to the trustee of his trust, "I want you to guard this for me, but you also have to tend my crops. You have to make sure that the king gets his bounty that's due the king and no more, and you have to provide for my family from this harvest." It's kind of, you could even rewind all the way back to Jesus of Nazareth's parable of the talents. I've entrusted certain wealth to my servants, and I expect some type of return on that, or at least the return of my underlying assets. But when it comes to who you select as the trustee, I'm a recovering lawyer, so I'm going to have to give you the lawyer's answer. It kind of depends on what you want the trust to do and what you want your relationship with the taxing authorities, and or from a asset protection and or privacy perspective, how much insulation are you looking for? In the context of the type of trust, I think, frankly, most everybody ought to have this revocable living trust. You will be your own trustee. You will be the creator of this trust. So you're the settlor. You will be the manager who manages all the day-to-day decisions. You'll be the trustee. And during your lifetime, you will be the primary beneficiary of this trust. You have not fundamentally changed your relationship with your property at all during your lifetime. You still have all the control. You can revoke this trust anytime you want to, and you can create a succession of trustees. You probably put you and your wife together as co-trustees. Why not? I mean, you're both managing things. It's for the benefit of you, your wife, and your daughter. Great. Those are the beneficiaries of this particular trust. You have no asset protection inside that trust. Why? Because you control everything. You can revoke the trust. You can pull money out of the trust. You're the beneficiaries of the trust. You have no asset protection over that trust. You have no tax benefits from that trust. Why? For the very same reasons. What the revocable trust does primarily is privatize the process of decision making. If something happens to you, or if something were to happen to your wife, you don't have to go through the judicial process of determining, hey, can I move the assets out of this account to this other account? It's all happening privately because the trust gives you the authority. You are the trustee. You are also the beneficiaries. You do what you need to do. And if you're not here, the successor trustee that you have named steps into your shoes, even though you might have died. The trust that owns the assets, that trust has not died. And so the trustee simply steps into those shoes. That's really how the basic trust will work. But when we're dealing with trusts that need to have, that are either dealing with a much higher level of wealth, and or are irrevocable for some legal reason or tax reason, you need to have some third party who serves as the trustee of that trust. Because if I create an irrevocable trust with the objective of getting the assets inside that trust beyond the reach of my creditors and or outside of my estate from an estate tax perspective, but I'm also the trustee and I can decide when to take assets out, I haven't done anything. There are all kinds of code sections in the Internal Revenue Code that tell me that I haven't changed my relationship with my assets. So I would have to nominate you or some other third party to be the trustee of my trust. Could I select my brother-in-law? Sure. Could I select my wife or my kid? Probably. But it would be very limited in the amount of discretion they could exercise because of how the IRS and how the tax code draws assets back into my estate. So if I really want the highest level of security and the highest level of flexibility in the trust and the highest level of confidence that the value of the assets will be beyond the reach of creditors and or outside of my estate from an estate tax perspective and or outside of the income tax regime in my state, I need to have an independent third party, which probably is going to get us into a trust company of some sort that's going to serve as the trustee of this now irrevocable trust.
Mm-hmm. What is the? And I think it's actually something to really underline because, and in some ways, it was the thing that stood out to me the most when we were emailing back and forth about what we wanted to talk about today, which is you talked about why everyone needs a revocable living trust, and then there's all these other interesting branches that we can talk about. But it was everybody there. It wasn't like, and I wonder if you want to define what income level we're talking about. But what is that wealth level where? Okay, like revocable living trusts are for everyone and should be for everyone if you care about these things versus when do you start thinking about more complexity?
Yeah. Yeah. I mean, I really do believe that fundamentally pretty much everybody who's got the luxury to sit and listen to a podcast on an afternoon should have a revocable trust, a revocable living trust. And again, it gets back to this idea of privatizing the process. It's about controlling the family's destiny. Because let's look at the alternative. If you're dealing with this right now, not to pack salt in the wound, but I mean you're dealing with this right now. When somebody dies with only a will, or when they have no formal estate plan at all, they are going through the statutory process of probate to make sure that someone who's trustworthy, in the case of your parents, you, will swear an oath in front of the court that you will faithfully discharge your duties and wrap up these financial affairs according to state law and or if there's a will involved, according to the terms of the will. If you don't have a will at all and you simply rely on the default provisions of the statute in whatever jurisdiction you happen to live in when you die, you are what's called intestate. And so then the state statutes have a default distribution pattern. And it's usually some combination of if you're married and don't have kids, but your parents are living, maybe your spouse gets half and your parents get half. If you don't have parents, or maybe if you're married and have kids, Maybe your spouse gets half and your kids get half. Sorry, if your kids are minors, now they're going into a guardianship. It's kind of a crappy way to default into what happens after, after you breathe your last. It's like now you've left a mess that's probably not necessarily consistent with what you want. Because I don't think that when people create a will, they probably don't say, hey, give half to my wife and half to my mom, or half to my wife and half to my kids. It's like, no, I want it all to go to my wife. And then only if my wife is not living, then to my kids, but I don't want to just dump loose in their lap. I want some kind of guardrails around that. Okay, well, if you don't have a structured plan, then you have no guardrails, and you haven't taken control of the process. And again, if you have a will, yes, you can absolutely take control of the process or the ultimate outcomes, but you're still subject to administrative oversight of the court, of the district court in whatever jurisdiction you happen to reside when you die. And a trust simply privatizes this whole process. It gives you the ability to control how the assets get managed, and whether it's for the benefit of a spouse or the benefit of kids or other people. Say, you know what, maybe I want some scaffolding around this wealth. If I've got young kids, or if I've got kids that I'm not sure make great decisions, or if I've got kids that are in high risk professions, maybe I want to create some protection around the wealth. I think that scales down to people who only have a couple $100,000. I don't think it takes somebody who's uber wealthy to have those types of concerns. And if you have any asset that has a title on it, whether it's a vehicle or real estate or brokerage accounts or you name it, that title is going to have your name on it, somebody's name on it. And so if that name on top of the title belongs to a incapacitated person or a deceased person, we're right back into this probate process. So that's why I believe that trusts are low-hanging fruit for probably everybody who's got, more than just the most modest wealth. Because who doesn't want this level of privacy, and who doesn't want to create some type of framework that will allow their spouse to not have to go to the courthouse if husband or wife has died, to allow the kids to grow into whatever wealth is left behind, even if it's just $50,000 a kid or a couple $100,000 a kid. If I were to inherit $100,000 outright when I was 20 years old, probably would have been disastrous. So yeah, I think that's why I say that the revocable living trust is pretty much table stakes, at least in the United States, for probably the vast majority of people. And then as the wealth grows, we can talk about, where you might start thinking about the next phase of planning beyond that.
Well, let's go exactly there. So what are the next phases beyond that?
Okay. I'm back to my lawyer's answer. Kind of depends on what your objectives are. But let's say that you are now, you're now among the more affluent class. You've got estates. Well, let me kind of pare it back a little bit. Let's say, first of all, maybe you live in a state that has state level estate tax. Those state level estate taxes may kick in at a much lower level than the federal estate tax exemption amount. For example, I think Maryland and Massachusetts both have estate tax exemptions of about $2 million, whereas the federal doesn't kick in until 13.61. So you might have state level estate tax exposure, but you may or may not necessarily have federal estate tax exposure. Maybe there, once your total wealth, your aggregate wealth, or your estate value, we might call it, which also includes things like the face value of life insurance that you own, or ownership in a closely held company, things that you don't necessarily think of as liquid wealth. As a quick aside, a lot of people are bullish about life insurance because they say it's tax-free. It's not. It's income tax-free when you receive it, but the value of the death benefit is includable in the estate of the insured person. So it's a misnomer to think that life insurance is tax-free. But that digression aside, you have to factor in things like the value of your term life insurance. Well, now if you're kind of tickling the $5 to $7, $8, $9 million, and you happen to be in a state that has state level estate tax, you might start thinking about getting some of the value out of your estate with some type of irrevocable trust. I might create an irrevocable trust for the benefit of my wife and my children, kind of proactively using part of my estate tax exemption for the people that I already care about, the people I'd give it to anyway. If I want to reduce the value of my estate from an estate tax perspective, that might be a way to think about that. And certainly once we get into the if you're an individual and you're probably north of 12 to $15 million, married couple, you probably ought to double that number. Now you really need to start thinking about more advanced estate planning strategies. Some type of irrevocable trust will probably be appropriate, but the type of irrevocable trust, the structure itself is going to be really dependent on the individual's unique values and objectives.
Have you noticed throughout your career that the types of folks that come for this type of planning are in particular verticals or industries, and maybe where others don't consider it? That's obviously going to be anecdotal, but I was wondering if there's a particular demographic that seems to latch on to these things, and maybe a demographic that either seems unaware or distrusts the process somehow or doesn't want to deal with it.
Yeah, that's a really interesting question. Yeah, I would say that usually it's people with families. They start really thinking about this. Young entrepreneurs, young successful people, are still kind of thinking that they're immortal and they're too busy building things. And death doesn't happen to me, or I'm never going to become incapacitated or whatever. And that's fine. I get that. Usually it's people who, when they have a kid, they start thinking, okay, wait a second. There's now this part of me that's going to live beyond me. How do I protect and provide for this person? And then certain industries, yeah, I think industries that are maybe a little bit more traditional. I think ag families often think about this kind of stuff because the land or the family enterprise is such a part of the family's identity, and they want that identity to be preserved and manifest in future generations. So successful business families, successful landowners, ranch families, oil and gas families, they really get this stuff almost immediately. Where we've gone through some learning. I mean, this story, but your audience probably doesn't. Where we've seen a lot of evolution in this space is in the crypto world, because that really created the impetus for us to form Bespoke as the family office in that space. But a lot of people who got into Bitcoin fairly early ended up with a surprising amount of wealth that they hadn't expected. And a lot of the Bitcoiners have been in it for a long time, and that's kind of an older cohort. It's a cohort that is at least aging and now having their own families, and kind of like farm families, kind of like family business families or oil and gas families, they see Bitcoin as a long-term family store of value asset that they probably don't really plan on liquidating. They might borrow against it, they might do other things with it, but it's going to serve as a part of the bedrock of the family wealth long term. And so they're interested in these kind of transgenerational legacy structures, forms of irrevocable trusts that will be tax efficient and protected down through the generations. But of course, when you're dealing with unusual assets like that, the planning becomes a little bit more complicated. I think the clients who are slowest to move on estate planning are the venture fund cowboys and the crypto bros who are out there just making money hand over fist and just doing their thing. But that's okay. They'll come around.
Yeah, I guess so. I'm already going over time, but so I'll get you out of here on this, and maybe this sets the stage for one of our next conversations at least. But you know, unless you're living under a rock, and I envy you if you're living under that rock, you know that we're in a U.S. presidential election cycle, and that there are lots of different changes on the horizon with that cycle. I think one of them that is most pertinent from our perspective here is, currently the way that the lifetime estate and gift tax exemptions are going to change as of January 1st, 2026. And the question that I wanted to lead up to was, um, obviously something like a will can become out of date very, very quickly if something changes with a law. And my impression is that that could be true of a trust, but that it would be much harder to invalidate sort of the strategies or the tactics or the things like that that have been parked into a trust in that way, that you're getting resilience against a political system that does change because things are either going to be grandfathered in or because you're going to have multiple layers of protection rather than just making a plan that was fit for the laws today, right now. So I wanted to give you a chance to riff on that. And if you want to talk about anything as a cliffhanger that worries you in particular, whether from a trust perspective or just from an estate planning perspective in general, with the dumpster fire that is our political system right now.
Yeah, I mean, I think there are a couple of ways I think about that. When we're dealing with things like the federal estate tax exemption, just as a quick maybe refresher for your listeners, the federal estate tax exemption pre-2017 was set at $5 million per U.S. taxpayer. When the 2017 Tax Act came through, signed by Donald Trump, the exemption was doubled from $5 million to $10 million per taxpayer. That number gets adjusted for inflation annually. So the current 2024 estate tax exemption amount is $13.61 million per U.S. taxpayer. That is an exemption that you can use, that you can apply to gifts, completed gifts that you make during your lifetime. And if you haven't used it up during your lifetime, then whatever's left you can use up when you die. But as you mentioned, the federal estate tax exemption is automatically scheduled to sunset at the end of 2025. So that's just a feature of tax laws. So you wake up, barring any other action by Congress and the president, we'll wake up January 1 of 2026, and this nice, comfortable $10 million plus indexing for inflation exemption just got cut in half. When you're planning to only use the estate tax exemption when you die, if you're only planning on when you die, you can do the same level of estate tax-oriented, flexibility-driven planning with a will that you can do with a trust. As I mentioned before, the trust just privatizes this process. You can make sure that if you're married, that you can gift property to your surviving spouse in a way that just defers the estate tax until your spouse passes away down the road. You can kick that can down the road to whatever the estate tax law will be when your spouse later dies. That's one option. But when we are staring down the barrel of a scheduled halving of the estate tax exemption amount at the end of 2025, a lot of affluent families are saying, well, I don't want to just die in 2025 and use up my estate tax exemption. I want to use that as a gift during my lifetime. So I will create a completed gift into an irrevocable trust, and I will just use my estate tax exemption now, proactively during my lifetime. And then we already have guidance from the Internal Revenue Service that we've got regulations that say they will not claw back gifts made during lifetime under this high exemption period. So if we do wake up in January of 2026 and we see that the exemption has been cut in half indeed, then the gifts that we have made this year and previous years are outside of our states, and that's all wonderful. If Congress and the president do create some new massive tax law in the future that, again, extends these exemption amounts or raises them or completely obviates the need for estate tax-driven planning, there will be something. But trusts do provide for levels of flexibility beyond that. But I think right now we kind of have to plan for what we know. We know what the law is right now. We know that we have these large estate tax exemptions, historically high estate tax exemptions, and we know that under the current law, those will end at the end of next year. So affluent families are really doing a lot of active estate planning now to use their exemptions, shift the value out of their estates. I think the one thing I really want to leave your listeners with is the notion that irrevocable trusts don't have to be scary. People think, well, if I create this irrevocable trust, I no longer have any access to those assets. I can't do anything else with it. It's just now it just has to sit there. That's not the case. Irrevocable trusts can become really compelling family reinvestment vehicles. You can take assets that are in these trusts that are outside of your estate, and you can redeploy that capital. You can build new companies. You can create new portfolios with inside those things to build and compound family wealth. And there are other types of trusts that can shift the value out of your estate, but provide benefits to your spouse, benefits to your kid, and even some that create backdoor, a backdoor that you can have access to again if really the rain comes and all your assets are inside these trust structures. You can actually, there are plugs you can pull that will drag it back in. So I would encourage people to not be afraid of irrevocable trusts. Yeah, they're complicated. It's the tax code, but they don't have to be scary, and they can provide a lot more control than a lot of people really think they can.
Well, I wanted to do Trust 101 and I wanted to keep it engaging, and I think we did that. I think you've said everything you wanted to. Anything else you want to close out with before we leave this topic, Matt?
Um, well, I don't know if you want to go down this rabbit hole or not, but I'm a big fan of privacy, as I'm sure has come out in this. One of the cliffhanger I might leave you with is the what I perceive as a profound invasion of privacy under the Corporate Transparency Act that took effect in January of this year, that requires all beneficial owners of things like limited liability companies to now disclose all of their information to a financial crimes enforcement network database within the Department of Treasury. This captures family businesses, not just your everyday mom and pop hardware store, but the LLC that a family might create for the sole purpose of managing family wealth. And so folks need to be aware of this Corporate Transparency Act. They need to be aware of their compliance requirements, and they should potentially consider if there are ways to restructure that can start to reclaim some privacy around the margins in a world where it's pretty much out there all in the open.
Yeah, I'm glad you said that, because I do think it's one of the focuses here. Because I mean, you talked about structuredness and predictability, but also privacy as one of the most important aspects here. And as speaking to somebody who I'm in that geriatric millennial demographic bucket. So old enough to remember when the internet wasn't around, but I was pretty young when that happened. Like, it was sort of a nostalgic sort of area gone past. And I think that folks who have that experience, I mean, I'll speak for myself here, but I think I can extend it beyond others, is that we're just sort of used to having everything out in the open. And like, the 90s was a really heady, optimistic time. And we were all on AOL messaging each other and going to strange chat rooms and like bearing our souls, and on MySpace and then on Facebook and then on this, that, and the other thing. And the world was a gentler place then. It was a more trusting place. And we thought that we were going in a direction where openness was going to lead to good outcomes. Um, and I hate to say it because it cuts against like my own sense of optimism, but I don't think you could say that anymore. And there's a lot of information that's out there that gets used against you. And that openness has turned in sort of a sinister direction, and maybe and hopefully it will go back in the other direction. But until it has, I think to the extent that you can reclaim some of your privacy, it's important to think about. It's going to be impossible to reclaim it all in a digital world. So unless you want to, get back off the grid on the farm with me in Georgia, which I'm actively trying to do, it's not going to be possible. But I do think it's really something to underscore in everything that we talk about.
Yeah, again, I think that's why it's important to try to reclaim privacy around the margins. I think the genie is out of the bottle. We're never going to get her back in. Um, but my wife thinks I'm just crazy about this. I mean, I'm a if you're an elderly millennial, I'm an elderly Gen Xer, so I'm a step ahead of you. I remember in a world without cell phones altogether. I remember when the first dial-up modems became a thing, and I thought I was the coolest guy because I had a pager on my hip in the late 1990s, but or early 1990s, I guess. But yeah, I think again, I try not to project too much onto my clients. This is stuff that I'm also hearing from my clients that are older than me, clients that are younger and sometimes much younger than me. They're concerned about how easy it is for people without their best intentions to find where people live, and to kind of track them down, and sometimes just out of the sense of curiosity. And so affluent people who are successful in any industry, um, should be mindful not only of their social media behavior, but even how they title assets and trusts and foundations and sometimes certain companies as part of the appropriate strategy stack that a family might have can create layers of insulation for privacy, for asset protection, for long-term family wealth governance, um, tax mitigation. I mean, there's just lots of reasons to do it, but yeah, it's complicated and it can go in any number of different directions.
Well, and it's I very rarely use this word. It's unprecedented in human history that the level of data and information that is out there about our personal lives. I think people who try to dismiss it, it's a problem that is too big for them to handle, and it's a problem that we've never had to face before. But I mean, it absolutely is a problem, whether you're affluent or not. It's not good to be able to have anyone come look up like where you are and get to where you are. That's not a problem that we used to have back when the Crusader Knights were first establishing the first irrevocable grantor trusts in the English countryside.
Yeah, that's right. It just becomes a bigger problem. The more successful, the more financially successful a family gets, the more pronounced the problem becomes.
Well, and really starts to, and again, like it starts to affect everyone too. I mean, just there's the promise of AI, and then there's the deep fake side of AI, and there's the promise of increased efficiency, and then there's fraud and scams, and how much better those things are going to get. Um, and you may be able to protect yourself from them now, but I mean, we've talked about my family here in the context of this podcast, and I'm fine doing it. The will stuff and the probate stuff, whatever, is fine. But one of the most disturbing things about watching my dad age was all these scammers that were going after him, trying to get information and trying to get money and trying to get access to accounts. And he wasn't with it. It was fairly easy. And that's for somebody who was at the end, who wasn't used to this level of technology. I think that's going to come fast and heavy for a lot of us now. And even for us geriatric millennials who are like, yeah, we were here when the internet was invented. Like, we're savvy. We have no idea what's coming. We're not native to the new stuff at all.
No, that's exactly right. And I guess the last thing I would say is that these successful families, it's usually a wealth builder, or a husband or a wife or a mom or a dad who has built significant wealth, and they may have all the savviness in the world. They may understand all these strategies, but their children may not have any appreciation for their own exposure to the risk. And so families need to be thinking multi-generationally, not just about their wealth, but also about privacy, and preparing children for the fact that they may just be in part of the blast radius of mom and dad's success. And how can you minimize the fallout within that blast radius?
Yeah. All right. We'll leave it there. Matt, thanks so much. Let's get to the bourbon part of the conversation. Cheers. The views expressed in this commentary are subject to change based on market and other conditions. This podcast may contain certain statements that may be deemed forward-looking statements. Please note that any such statements are not guarantees of any future performance, and actual results or developments may differ materially from those projected. Any projections, market outlooks, or estimates are based upon certain assumptions and should not be construed as indicative of actual events that will occur. Cognitive Investments LLC is a registered investment advisor. Advisory services are only offered to clients or prospective clients where Cognitive and its representatives are properly licensed or exempt from licensure. For additional information, please visit our website at www.cognitive.investments. The information provided is for educational and informational purposes only and does not constitute investment advice, and it should not be relied on as such. It should not be considered a solicitation to buy or an offer to sell a security. It does not take into account any investor's particular investment objectives, strategies, tax status, or investment horizon. You should consult your attorney or tax advisor.